from such conduct under the Title VII 7 of the Civil Rights Act. In 1964, the Americans with Disabilities Act, ADA, the Age Discrimination of Employment Act, ADEA, the Equal Pay Act, DEPA, and of 1963, and the Genetic Information Non-Discrimination Act, GINA. In order to migrate claims of discrimination, employees need to train their supervisors about avoiding acts of discrimination in employment decisions. Likewise, employees need to be trained on anti-discrimination policies and be informed on how to report incidents of discrimination and assured that such reporting will not in any way result in retaliation. Black's Law Dictionary defines discrimination as the failure to treat all persons equally, where no reasonable distinction can be found between those favored and those who are not favored. In other words, discrimination is the unfair treatment or denial of standard privileges of employment, such as benefits of working hours, pay increases, transfers, or promotional biased on one's race, age, sex, nationality, pregnancy, religion, gender, identity, genetic information, marital or veteran status of handicap, whether physical or mental. Discrimination is prohibited in all phases of employment, including hiring and firing, compensation assignments or clarification of employees, transfer, production, layoff, or recall, job advertisements, recruitment, testing, use of company facilities, training, and apprenticeship programs, fringe benefits, pay, retirement plans, and disability leave, or other terms of conditions of employment. Discriminatory practices under these laws also include harassment on the basis of race, color, religion, sex, national origin, disabilities, or age. Retaliation against any individuals for filing a charge of discrimination, participating in investigations, or opposing discriminatory practices, employment decisions based on stereotypes or assumptions about the abilities, traits, or performance of individuals of a certain sex, race, age, religion, or ethnic group. Genetic information on individuals with disabilities and denying employment opportunities to a person because of the marriage to or association with an individual of a particular race, religion, national origin, generic information, or an individual with a disability. Title VII also prohibits discrimination because of participation in schools or places of worship associated with particular racial, ethnic, or religious groups. There are two categories under which most employment discrimination claims fall: desperate treatment and desperate impact. Desperate treatment occurs when an employee commits international discrimination, such as harassment or refusing to promote or hire an individual because of their color. This desperate impact is generally not international, but results from an employment practice that on the surface appears to be neutral in treatment, but actually treats one group of people more negatively than another. Furthermore, the practices are not justified by business necessities. Examples of desperate impact include establishing a dress code, educational requirements, or height and weight requirements. Supervisors who are not trained to recognize this desperate impact discrimination may unknowingly put their employer at risk of a lawsuit. When an employee reports a case of discrimination, supervisors need to be trained to respond quickly and thoroughly. Discrimination is usually subtitle, and there is rarely a smoking gun to determine what factors were considered. In a decision making process, supervisors will need to know how to conduct an investigation of all the surroundings, facts, and circumstances. Generally, just one piece of evidence is not enough to determine whether discrimination was a factor. Multiple um, av- avenues may need to be investigated to find evidence that substantial substantially the claim. Sources of information can include witnesses' statements, including consideration of the credibility, documents, direct observation, and statistical evidence, among others. An employer's best defense against discrimination is to develop a strong EEO policy that is clearly communicated and accepted by both managers and employees. Training is an important element, and making sure to enforce the rules is permanent. Training topics should include race discrimination, religious discrimination, national origin discrimination, age discrimination, disability discrimination, pregnancy discrimination, genetic discrimination, sex gender discrimination, compensation discrimination, citizens discrimination. Required posting. The law requires an employer to post notices describing the federal laws prohibiting job discrimination based on race, color, sex, nationality, origin, religion, age, equal pay, disability, and genetic information. Every employer covered by the non-discrimination and the EEO laws is required to post on its premises. The poster equal employment opportunity is the law. The notice must be posted promptly where it can be readably seen by employers and applicants for employment. Harassment. Under the same laws that govern discrimination, employers are also responsible for preventing harassment in the workplace. Although there has been a lot of attention given to sexual harassment in recent years, harassment can take many forms of same groups of people that are protected from discrimination are are likewise protected from undergoing unwelcome offenses. Conduct based on sex, race, other than prohibited characteristics. These types of behavior create a hostile work environment and constitute discriminatory harassment. To determine if an action is considered harassment, it must be viewed as such by the people that it affected, not by the ones responsible for it. An employer may not have seen as or even meant their words or actions to be harassing in nature, but if the victim felt uncomfortable or insulted when it would be classified as harassment. If the action is not welcomed by the victim, then the offense has occurred. Some of the most common forms of unwelcomed behavior are jokes and that are sexual and in nature or offend one's race or gender. Lewd comments about sex are prohibited. Characteristics, offensive emails or insults messages. Plain suggestive music in corporate written materials such as love notes. Offensive or derogatory remarks about an applicant or employee's genetic information or the genetic information of a relative of an applicant or employee, such as racially derogatory words, phrases, interprets. Demonstrations of the racial or ethnic nature, such as use of gestures, pictures, drawings, such as would offend a particular racial or ethnic group. Comments about individuals' skin color or other racial ethnic characteristics. Negative comments about employees' religious beliefs or lack of religious beliefs. Expressing negative stereotypes regarding the employee's birthplace or ancestry. Negative comments regarding an employee's age when referring to employees 40 and over. Derogatory or intimidating references to an employee's generic information, mental or physical impairment. Accepting conduct is not the same as welcoming. It is a person is not welcoming a conversation or action just because they fail to say anything. They may even participate in the conversation, but they feel offended by what someone in the group is saying. Furthermore, just because a person likes something today doesn't mean they will welcome it tomorrow. For example, if two employees are dating by marital consent, but then break up, what was acceptable a week ago may now be unwelcome. Anyone, regardless of gender or job level, can be guilty of harassment. The harasser can be the victim, supervisor, an agent, or an employer. A supervisor in another area, a coworker, or a non-employee. The victim as well as the harasser, non-employee. The victim as well as the harasser may be a woman or a man. The victim does not have to be of the opposite sex, and the victim does not have to be the person harassed, but can be anyone affected by the offense conduct. Harassment becomes unlawful where enduring the offense conduct becomes a condition of continued employment, or the conduct is severe, preserves through to create work environment that is a reasonable person would consider intimidating, hostile, or abusive. As a discrimination, employee can mitigate claims of harassment by training supervisors to avoid actions that may be construed as offensive, or by recognizing signs of hostile work environment. Additionally, supervisors must be trained in immediately responding and investigating reports of harassment. Likewise, employees should be educated about anti-harassment policies and what to do should they feel they are a victim of harassment. Vic, 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 Vicarious employer liability standards. Even more reason to make sure that supervisors are versed on what actions are prohibited. Under anti-harassment laws is that employees can be held legally responsible for the actions of their supervisors. The accountability is known as vigorous liability and is especially prevalent in harassment cases. The Supreme Court has ruled Burlington Industries Incorporation of Elith and Frayer City in of Boca Corporation that an employer can be held responsible for harassment committed by a supervisor if the harassment was committed by a supervisor with immediate or successively higher authority over the employee. The standard of liability is based on two principles. One, an employer is responsible for the acts of its supervisors. Number two, employers should be encouraged to prevent harassment, and employees should be encouraged to avoid or limit the harm from harassment. The Supreme Court reasons that vigorous liability and supervisor harassment is appropriate because supervisors are added on such misconduct by the authority that the employers delegated to them. Therefore, the authority must be of the sufficient magnitude so as to assist the harassment explicitly or implicitly on carrying out the harassment. The determination as whether a harassment has such authority is based on his or her job functions rather than job title. Team leaders and must be based on specific facts. Implementing an EEO policy, it generally is necessary for employees to establish, publicize, and enforce anti-discrimination and anti-harassment policies and complaint procedures. As the Supreme Court stated, Title VII is designed to encourage the creation of anti-harassment policies, effective governance mechanisms. ELLERTH 118 SCT at 2270. While the court noted that this is not necessarily necessary in every instance as a matter of law, failure to do so will make it difficult for an employer to prove that it exercised reasonable care for to prevent and correct harassment. An employee should provide every employer with a copy of the policy and complaint procedure and redistribute it periodically. The policy of complaint procedure should be written in a way that will be understood. So you want to put the thing and then you want to put at the end all the time in a letter, to whom it may concern, and write whatever you're going to write, and then put that if immediate action does not get corrected, that you promise to obey all laws, and if it doesn't get corrected then you will make sure that immediate action is made, will be made, and you'll pursue that. So make sure that you're like pretty firm on it, and make sure you have the dates on there, because at least give it a 2 weeks to have that resolved. Hopefully you should hear something within 3 days, and give 3 copies, make a copy for you, make a copy for them, and make sure that they have a copy in file, and you also have another a copy in file. So it's always good to have several copies every time you're going to report. So employees in the employer's workforce, other measures to ensure efficient discrimination of the policy and complaint procedure include posting them in central locations and incorporating them into employee handbooks. If feasible, the employer should provide training to all employees to ensure that they understand their rights and responsibilities. And anti-discrimination, anti-harassment policy, and complaint procedures should contain, at a minimum, of the following elements: a clear explanation of prohibited conduct, assurance that employees who made complaints of discrimination, harassment, or provide information related to such complaints will be protected against retaliation. A clearly described complaint process that provides accessible avenues of complaint, assurance that employer will protect the confidently of discrimination, harassment, and complaints to the extent possible. A complaint process that proves a prompt, through, and impartial investigation, and assurance that employers will take immediate and appropriate corrective action when it determines that discrimination, harassment has occurred. Effective investigation process: an employee should get up to mechanism for a prompt, through, and impartial investigation into a line discrimination or harassment as soon as management learns about alleged discrimination. It should determine whether the detained fact finding investigation is necessary. For example, if a supervisor or aligned harasser does not deny the accusation, there would be no need to interview with it witnesses, and the employer could immediately determine appropriate corrective action. The employer should always write the dates down. If the fact finding investigation is necessary, it should be launched immediately, and amount of time that it will take to complete the investigation will depend on the particular circumstances. If, for example, multiple individuals were allegedly discriminated against, then it will take longer to interview the parties and witnesses. It may be necessary to undertake intermediate measures before completing the investigation to ensure that further discrimination does not occur. Examples of such measures are making scheduling changes so as to avoid contact between the parties, transferring the person who allegedly partook in the discrimination or harassment, or in the case of harassment, placing the alleged harasser on the non-disciplinary leave with pay pending the conclusion of the investigation. The complaint should not be involuntarily transferred or otherwise bur- buried, burdened, since such measures could constitute unlawful retaliation. The employer should ensure that the individual who conducts the investigation will objectively gather and consider the relevant facts. The people being investigated should not have supervisor authority over the individual who conducts the investigation, and should not have any direct or indirect control over the investigation. Whoever conducts the investigation should be well trained in the skills that are required for interviewing witnesses and evaluating credibly. The EEO system policy, simple policy: the company is committed to ensuring equal opportunity, EEO, and promoting workforce diversity to maintain a strong, effective, high performing public service organization. We support that vigorously enforce all applicable federal EEO laws, regulations, execute orders and management directives, and ensure that all individuals are afforded by equal opportunity for success. The relevant laws include Title VII of the Civil Rights Act in 1964, the Americans with Disabilities Act, ADA, and the Age Discrimination in Employment Act, ADEA. Age Discrimination in Employment Acts, ADEA, the Equal Pay Act, EPA, of 1963, and the Genetic Information Non-Discrimination Act, GINA. This Information and Non-Discrimination Act, this company will not tolerate discrimination or harassment on the basis of race, color, religion, national origin, sex, sexual orientation, job genetic information, or disability, or retaliation for opposing discriminatory act procedures, practices, and participating in discrimination complaint proceeding. This applies to all personal practices and terms and conditions of employment, including recruitment, hiring, promotions, transfers, reassignments, training, career development, benefits, and separation. In addition, the company will provide reasonable accommodation to qualified individuals with disabilities and for religious practices as provided by the applicable laws and procedures. To enforce the policy, the company is empowered to administer the impartial and effective compliant management process to address and resolve complaints of discrimination in the earliest possible stage. Employees may report allegations of discrimination to their immediate supervisor and other management official, their collective bargaining unit, or human resources as appropriate. Please note the employees must report all allegations within 45 calendar days of the date of the alleged incident. And in order for a complaint to be investigated, allegations, discrimination, and harassment will be immediately addressed, and appropriate corrective action up to the including termination will be taken of allegations and are sustained. The company is firmly committed to ensuring that all employees, applicants, contracted employees, clients, and customers, and anyone doing business with the company is not subject to discrimination, harassment, form